Point of order, Murdo Fraser.
Thank you, Presiding Officer. I wish to raise a point of order in relation to the legislation. We are about to consider the Non-Domestic Rates Liability for Unoccupied Properties Scotland Bill. As you will be well aware, in terms of the Scotland Act, this Parliament can only pass legislation that complies with the terms of the European Convention of Human Rights. I am concerned that the bill before us breaches Article 1, Protocol 1 of the Convention and is therefore legislatively incompetent. The bill seeks to change the law around the liability for non-domestic rates on unoccupied properties, curing what appears to be a defect in the legislation passed by this Parliament in 2020. There is no legal difficulty in this Parliament legislating that, from this point, liability should change. However, this bill is also retrospective in impact, dating back to charges levied since 1 April 2023, and it is this aspect that causes a legal difficulty. As matters stand, those who have paid non-domestic rates on unoccupied properties since 1 April 2023 have a clear patrimonial right in Scots law to seek repayment under the principle of unjustified enrichment. This bill seeks to retrospectively extinguish that right in order to protect the public finances. That position is stated plainly in the policy memorandum. At paragraph 29, the Government acknowledges that the revenue was collected without a valid legal basis. At paragraphs 41 and 42, the memorandum concedes that the bill retrospectively validates those payments and removes the right to repayment solely to avoid the fiscal consequences of its own legislative error. Now, Presiding Officer, the law in this area is clear. The retrospective extinguishing of a right of possession under Article 1, Protocol 1, without compensation, is a serious interference that requires the strongest justification. Case law has determined that such action could only be taken without payment of compensation only in exceptional circumstances. The policy memorandum we have today is entirely unconvincing as to whether the arguments put forward by the Scottish Government to meet the test of exceptional circumstances. In effect, the Scottish Government is trying to argue that legislative incompetence amounts to exceptional circumstances under the law. I do not believe that is a credible position which would survive a legal challenge in the courts. Now, Presiding Officer, I wrote to the Presiding Officer this morning in more detail to raise my concerns about the legislative competence of this bill in relation to its retrospective impact, and I am grateful to the Presiding Officer for her response, which I received this afternoon. Further to that, I would be grateful if you could advise me what mechanisms are available to members of this Parliament to test the arguments I have made, particularly given the very shortened timetable for scrutiny of the bill before us, to try and avoid the inevitable legal challenge which will follow if this legislation is now passed.
Can I thank Mr Fraser for advance notice of the point of order, and as he says, in response to the letter he sent the Presiding Officer, she's provided a more detailed response. But I think for Mr Fraser's benefit and the wider chamber, I would observe that the Presiding Officer takes the view on the legislative competence of each bill at its introduction. Her statement is informed by robust advice and forms part of the information before the Parliament to assist with the scrutiny of a bill. I think to the point that Mr Fraser was making just a second ago, members may raise issues of interest to them, including matters relevant to the legislative competence as part of the debate if they wish to do so. Scotland Act 1998 provides for further checks after a bill has been passed, whether a provision of a bill as agreed by the Parliament within the Parliament's legislative competence can only be definitively determined by the court. And I hope that is of some help to Mr Fraser and to the Chamber. Point of order, Douglas Ross.
Thank you, Presiding Officer. And I apologise for not giving you advance notice of this point of order, but I think it is important that the Chamber is aware that in the last hour, Graham Day has had to write to the Presiding Officer and to me to correct the record in yesterday's debate. Because Graham Day, the Minister urging his own MSPs and those across Parliament to back an emergency piece of legislation, told me in response to an intervention that the Government were first made aware of the flaws in their legislation in August. Graham Day has now put on the official record that it wasn't August, it wasn't even July, it was in June. the government knew about this in June. So when I said yesterday that people outside of this building wouldn't believe something can credibly be called an emergency piece of legislation if the government had known about it since August, they will be even more confused as to why this government thinks something is an emergency now at the end of November when they knew about it in June. So I think this raises serious questions. First of all, it was bad enough that the Minister wasn't over the detail in the Chamber and he gave that answer. And I would be very keen to know if the Minister had been briefed to say it was August or if it was just a slip in the tongue. Because secondly, I understand from my business manager and from Craig Hoy, who's leading for our party on this issue, that in briefings with ministers, opposition politicians were also told August. So not just a minister misspeaking in the Chamber, potentially getting a note wrong, when they were trying to inform other MSPs to get them on side, because I do remember some of the discussions were, let's get this through as quickly as possible, no amendments, little fuss here, they were actually telling opposition members that August date. My question to you, Presiding Officer, is what date was the Presiding Officer of this Parliament told? Because if the Government put the case to our Presiding Officer, the guardian of what we do in this Chamber, that it was August, and it now turns out it wasn't August, it was 2 months earlier, it was June, that raises huge questions about not just what this government tell MSPs, but about what this government tells our Presiding Officer. And therefore I'm asking, Presiding Officer, one, if you can provide that answer, and secondly, if you will accept a motion under Standing Order 17.2 to suspend standing orders to allow us to rerun that emergency legislation debate which the government brought forward yesterday in light of this new information. Because I believe and hope that actually now, even if SNP members have heard their own government knew about this 2 months earlier than they said yesterday, they could change their minds. They could say this government had more than enough time to deal with this before the last week of November, because they knew about it not just in the last few weeks or months, but before this Parliament even rose for the summer recess. We were still sitting. We hadn't gone away on recess. But they chose to remain silent. And I genuinely think there will be SNP members now uncomfortable that their minister wasn't over the detail yesterday, but more crucially, that their government knew about this months before they told this Parliament, and that is why I believe it would be important for us to have that debate and vote again, and a suspension of standing orders under Rule 17.2 would be the right way to do that. Thank you.
Thank you, Mr Ross. That is not a point of order. Nevertheless, in response to the questions you ask, I am not aware of the date on which the Presiding Officer was informed. I am not minded to accept the motion without notice. I am aware that the Minister has written to the Presiding Officer clarifying the position, I think copying in the business managers as well at the same time. That is an appropriate means of correcting the record. And I think the other issues that Mr Ross has raised can quite reasonably be raised during the course of the debate that we are about to proceed with. On that basis, the next item of business is a debate on motion 19891 in the name of Ivan McKee on non-domestic rates, liability for unoccupied properties, Scotland Bill at Stage 1. I invite members wishing to participate to press the request to speak buttons now or as soon as possible, and I call on Ivan McKee to speak to and move the motion up to 7 minutes. Mr Minister.
7 minutes. Thank you, Presiding Officer. Presiding Officer, we are here today to debate Stage 1 of a bill that seeks to correct a legislative error and ensure that there is a clear legal basis for local authorities to collect non-domestic rates from the owners of unoccupied property. I welcome Parliament's agreement that this bill can be designated as an emergency bill, reflecting the gravity of the situation and its importance to public services and indeed to businesses. This is a serious matter which ministers have sought to resolve as quickly as possible. The bill we are discussing today will help us protect public revenue, which plays a fundamental role in funding the public services on which we all rely. It will prevent us from potentially having to cut £350 million of funding from our schools or our hospitals, or indeed increasing the rates liability for non-domestic properties in future. I'll make a wee bit more progress and then perhaps later. The Scottish Parliament voted, as members know, in 2020 to devolve empty property relief to local authorities, to provide greater local fiscal empowerment for councils by letting them, rather than the Scottish Government, decide whether to offer any rates discounts to the owners of unoccupied properties. To do this, a Government amendment at Stage 2 of the Non-Domestic Rates Bill in 2019, approved on a cross-party basis at committee, repealed legislation from 1966 that provided that no rates were payable on unoccupied properties, and also repealed a power that allowed ministers to prescribe by regulation classes of unoccupied properties for which such rates were payable. Empty property relief was devolved on the 1st of April 2023, and local authorities were given £105 million of additional revenue funding each year, equal to the forecast cost of this relief before it was devolved. Councils which are accountable to their local electorate have full flexibility over how they deploy those extra resources locally. However, a technical error in the Non-Domestic Rates Scotland Act 2020 was recently identified, which means that these amendments did not have the intended legal effect. While Section 19(2) of the 2020 Act repealed Section 24 of the Local Government Scotland Act 1966, which stated no rates were payable for unoccupied non-domestic property, the effect of Section 16(1) of the Valuation and Rating Scotland Act 1956, which sets out that rates shall be payable by occupiers only, was regrettably not taken into account. In the interest of transparency, Presiding Officer, I can inform the Chamber that a routine inquiry about the basis for rates to be charged to the owner of unoccupied properties was received from a council by Scottish Government officials on 23rd of June. There was no indication at that time of the implications of the query, and it was treated as routine. In investigating this issue, it became apparent to Scottish Government officials that there may have been an error in the 2020 legislation. Initial concerns were notified to ministers on 21st of August, and this concern, following further investigation and legal advice, was confirmed to ministers on 19th of September. Ministers agreed that the introduction of legislation be explored, and officials have worked at pace to develop the bill and secure a parliamentary slot, since then taking into account the 3-week period required for the laying of legislation. And I'm happy to take interventions.
Craig Hoy.
I thank the Minister for giving way. He has in part answered the question I was going to ask in terms of the party that has challenged the legislation. Can he say that since June the 23rd have any further parties come forward, and can he say in which local authority area this case pertains?
Minister.
No other parties have come forward in this regard, because this was an issue that wasn't known about, and there's only been one council that's come forward. I don't know if I want to give the name of the council, but I won't do that at this stage, because that's up to the council to identify that. Yes. Sorry, yeah, finish with that. Yes to Martin Whitfield.
I'm very grateful, Daniel McKee, to take the intervention. It's in really pursuit to try and find clarification of the situation. Can the Minister confirm that what he described as a routine request with regard to enforcement was indeed one that was created internally within a local authority, pleased to keep that private, rather than an approach that had been made to a local authority by someone out with it, questioning the ability to raise the...
I would need to check back in the detail on that, but as far as the Scottish Government is concerned, the request came from a council, was their internal council officials asked the question of Scottish Government officials what was the basis for the process that we're currently discussing, and then that was considered internally and then taken forward through the mechanism I've described. Who's next? Pam Duncan-Glancy.
Pam Duncan-Glancy.
I thank the Minister for taking that intervention, and given the dates involved and the slight confusion around it, can the Minister confirm whether he's willing to publish all internal correspondence about this error and the timeline surrounding it?
Minister.
And we're absolutely, of course, willing to, in the interest of transparency, cooperate with any requirements in that regard. Is that everyone? Okay.
Jeremy Balfour.
Jeremy Balfour.
I'm grateful to the Minister. I wonder if I can just seek clarification. When did the Scottish Government decide that legislation would have to be brought to this chamber? On what date was that decision made? Because it seems to me that even if we wait till August, September, to wait for 2 further months to bring this doesn't make it emergency legislation. So when did the government come to a view that primary legislation would be required?
Minister, I'll give you the time back for the
No, thank you very much. So, as I indicated in my earlier remarks, initial concerns were notified to ministers on the 21st of August, and that's the first date that ministers were aware that there was a potential issue. And then ministers further investigation and, of course, legal advice, as you would expect, to understand and investigate what was indeed the situation was undertaken, and the outcome of that was confirmed to ministers on the 19th of September. Ministers then agreed that the introduction of legislation should be explored, and so it was from that point that we started to take this process forward. And already indicated there is, of course, a 3-week period required for the laying of legislation. October recess was also in that space, but when we sat down at the end of September to consider this, we were absolutely focused on how quickly we could bring this forward to the Chamber. Make no mistake of that. So just to briefly conclude, Presiding Officer, primary legislation is required to correct this error and provide a clear and certain basis for local authorities to collect rates from the owner of unoccupied properties, and without that, the amounts paid would need to be refunded. The bill is therefore needed to bring the statute book unequivocally into line with Parliament's intention to devolve empty property relief to local authorities, and with the position as understood by local authorities and ratepayers, as applied by local authorities and as voted on by Parliament in 2019. The sums potentially at stake would fall to Scottish Government and are estimated to be over £100 million per year if local authorities have to repay the rates collected since the 1st of April 2023. There will be no changes to rates bill as a result of this legislation, and the bill, if passed, will not introduce any new additional costs to businesses or individuals compared to the Scottish Parliament's original intended policy. And for this reason, we have not consulted on the bill, which simply intends to rectify the position as it had been understood by Parliament, local authorities and ratepayers since the 1st of April 2023.
Maybe very briefly, Mark Griffin.
Thank you, Presiding Officer. Just a technical question to assist my understanding. I understand the position as to the non-domestic rates that have been paid, even though there was no legal basis for them to do so. But can I ask the Minister what the Government's understanding is of arrears or enforcement action that councils will potentially be taken against owners who have not been paying their domestic rates bill through this period? Does the Government have an understanding of the legal status of that debt and
Minister.
Yeah, in simple terms, I can clarify back on any specific examples that the member wants clarification on, but in simple terms, everything continues as if the legislation had been in place in terms of this bill from the date at which it was the policy was introduced. So everything is applied retrospectively. Presiding Officer, due to the importance of bringing clarity to the matter and the sums at stake, I hope members will support this important piece of legislation, and I move that the motion, the Parliament agrees to the general principles of the Non-Domestic Rates Liability for Unoccupied Property Scotland Bill is passed.
Thank you, Minister. I now call on Craig Hoy up to 6 minutes. Mr. Hoy.
Thank you, Deputy Presiding Officer. The Scottish Conservatives have very real concerns about this emergency legislation. Concerns about how we got here, concerns about the legality of the measures, and concerns today, Minister, that 2 days into us knowing about this situation, the Scottish Government's story is already changing. And I think at this point in time, could the Government be sure-footed in the answers that they give moving forward? Because I think to date we don't have confidence that they're on top of this issue. Now, Ministers today are saying that they have confidence that this tax can be levied retrospectively, when we all know, thanks to Mr Fraser, that the law states quite clearly that retrospective taxes can apply only in exceptional circumstances. Now, I heard what the Deputy Presiding Officer said to Mr Fraser about the legal competence of this bill, but as the formal response from the Presiding Officer to Mr Fraser makes clear, whether a provision of a bill is within the Parliament's legislative competence can only definitively be determined by a court. So will the Minister now or during this debate produce the legal advice? I know that the Government wouldn't routinely do this, but to confirm beyond reasonable doubt that these are exceptional circumstances. And if he cannot, then he should be very worried, because property developers are already in discussion with lawyers and murmuring the words unjustified enrichment. And will the Minister also confirm on the record that it is this Government and not councils who will be on the hook for £400 million that this could potentially cost, and all other associated costs? Now, this is £400 million in non-domestic rates levied on property owners without any legal basis. And whilst we don't want to delve too deeply into the impact of the legislation since it has been introduced, because at the behest of ministers the debate and the process will be too short for us to do so. But I think it is worth putting on the record that the £400 million levied illegally in rates has done a real and lasting damage to the commercial property market in Scotland since its introduction, and therefore to towns and to jobs and to industry. I will give way.
John Mason, briefly.
I thank the member for giving way. I mean, he emphasises that businesses have had to pay this, but I mean, where would the £400 million come from? Would you support cutting it from local authorities?
Craig Hoy.
Managed to magic up £1 billion in public sector reforms in the blink of an eye, so I'm sure he could find another £400 million in order to be able to do this. But the damage has been very real. As I said, some developers have razed buildings to the ground who could no longer afford or were not prepared to pay tens of thousands of pounds in tax for buildings they could not sell or rent. Others have collapsed corporate structures and simply handed back the keys, leaving the councils with the liability for hard-to-maintain properties. Now, the Minister's responsible for this defective legislation that this bill seeks to remedy were Derek Mackay and Kate Forbes. And looking back to the committee consideration at stage 2, it was clear that ministers did not do what was required of them in terms of legislative scrutiny or legal due diligence. Now, while the Government referred explicitly then to repealing Section 24 of the 1966 Act, they simply overlooked the existence of Section 16 of the 1956 Valuation Ratings Scotland Act. Kate Forbes and her legal team were simply asleep at the wheel. In fact, at stage 2 deliberations of the 2020 legislation, Ms Forbes told MSPs that the legislation was sound. She said, Amendment 42 delivers that by repealing legislation that provides no rates will be payable on unoccupied lands and heritage, it also repeals a power that allows ministers to prescribe by regulation classes of unoccupied lands and heritage for which such rates are payable. Although, she said, Amendment 42 is simple, the implications are significant, both for non-domestic rates policy and for local empowerment. So the Government believed the matter was simple, simply because they did not do their homework properly. They went back to the 1966 statute book, but apparently didn't go back any further. Now, Ms Forbes is meant to be the brains of the SNP operation, when in fact this was slapdash and it was shoddy. And who is to be held accountable for this minister? I see no signs of any heads rolling. But here we are again. As I said yesterday, the Government's solution to fixing a problem in legislation which was rushed is to rush through legislation. Now, I also have concerns about the lack of consultation. Ministers are saying that this is because they need to bring forward remedial legislation as quickly as possible after the concerns that were raised with them. But I do not accept in any way that if they have been able to spend 5 months giving due consideration to this, that they cannot consult even for a matter of weeks, and that we should be forcing this through in 2 days. Deputy Presiding Officer, we will not support this bill, and we will seek to amend it to the point where ministers have to go back and try to get it right. We also question the numbers. While non-domestic rates on unoccupied property may have brought in £400 million, what damage has this done to the commercial property sector and the construction industry? Wouldn't this be an opportunity to pause for some form of impact assessment to see what damage this legislation has done? And I think if the Minister was to go to speak to those within the industry, many of whom are very angry at the situation that the Government finds itself in, they will tell them in plain language what the effects of this tax have been. And on this basis, we could not support the financial resolution, because I think to support the financial resolution, given the significant doubts we have about the possibility of a legal challenge, would be to give the Scottish Government a blank cheque when it could face significant legal fees. Now, as I close, Deputy Presiding Officer, I just would like to point out that at stage 2 we will try try and amend this legislation in a number of ways. I believe Douglas Ross will quite rightly, and who will speak shortly, will try to make sure that we get greater transparency and greater accountability. This is the most significant legislative failure in recent years, and the Minister should not be seeking to try and brush this under the carpet. Independent scrutiny is needed to restore confidence in the system and to identify the lessons learned. Deputy Presiding Officer, I will leave it there. But this, I fear, is a bill fraught with difficulty, with complexity, and I appeal to ministers not to be frivolous with the legislative process now, as they were in 2020. They should pause, think, consult, and ensure they approach this in a proper manner.
Thank you, Mr Hoy. And I call Mark Griffin. Up to 5 minutes. Mr Griffin.
Thank you, Presiding Officer. On the face of it, this emergency legislation is a short and simple bill designed to rectify an error in the 2020 Act. As the law currently stands, local authorities have had no legal basis to collect non-domestic rates on empty properties from 2023 to the present day. Had this oversight gone unnoticed, the Scottish Government would now be facing refunds to business property owners amounting to around £350 million. Now, we intend to support the principle of this emergency legislation, not to spare the Government's blushes, but because it's necessary to correct this error, to bring the law back into line with the intent of the 2020 Act, crucially to ensure that the Scottish people, Scottish taxpayers, don't end up footing the bill, a £350 million bill for a Scottish Government mistake. But we can't ignore the fact that it seems like sheer luck that is all that stood between the Scottish budget and a refund bill worth roughly 3/4 of the Scottish child payment. That's not a small slip, Presiding Officer, that's a miss, a near miss of staggering proportions.
The member says that the Labour Party will support this legislation. Does he not have any concern about the legal issues raised by my colleague Murdo Fraser earlier on?
Mark Griffin.
I do have concerns about the legal issues. As the Presiding Officer said, though, all legislation passed in this place will ultimately face the scrutiny of the courts. What I'm more concerned about is the Scottish taxpayer having to foot a £350 million bill for a mistake of the Scottish Government's making it. And that is the consequence of us not passing this legislation. But the costly mistakes from this Government are becoming all too familiar. We've seen £1 billion spent on ferries that still don't sail, another £1 billion on a prison that was supposed to cost £100 million, millions more wasted on legal fees defending the SNP Government's own incompetence, and I hope no more legal fees as a result of this mistake again. Failure and mismanagement have already drained billions of pounds of public money. It's fortunate that someone eventually did their homework this time, because the country is well past the point where it can afford to keep paying for this Government's errors. And even though this issue appears to have been caught in time, there may yet still be hidden costs for local authorities, such as legal and financial advice to protect themselves from exposure as collection agents. And like Mr Hoy, I would like a reassurance that hard-pressed councils will not be expected to bear any burden for a blunder that was not of their making. I'm also still not clear, given the Minister's response to my point of order, that any debt recovery action that has commenced in the last few days, or indeed could potentially commence in the coming weeks, will be sound and could potentially have legal costs attached to that. Now, the Government will clearly be well aware that we are approaching a moment where the Scottish people will have the opportunity to hold them accountable. Their record on finances and taxation is woeful. We face a looming fiscal gap, and even with this legislative fix, the non-domestic rate system is simply not functioning as it should. It's a complex labyrinth of exemptions and reliefs, and that may well have been the thing that allowed this error to be undetected for so long. And it's not just financial legislation where this Government falters. Just last week we were summoned to the Chamber to question a phantom heat and buildings bill, only for the Government to admit that it had no intention of actually lodging it. These are not the actions of a government with a clear plan. They are the actions of a government that has run out of ideas and is rapidly running out of time. The Presiding Officer, I've said we will support this bill only to ensure that the Scottish people don't pick up the tab for this mistake. We know that when governments get it wrong, it's ordinary people who end up paying the price, and we firmly believe that public services should never have to absorb the cost of financial or legal incompetence from a government here that looks increasingly and sounds increasingly completely knackered, Presiding Officer.
Thank you, Mr Griffin. And I call Lorna Slater. Up to 4 minutes, Ms Slater.
Thank you, Presiding Officer. I do not intend to use my full time. The Scottish Greens understand the seriousness and importance of this bill and are content that the proposed solution to the drafting error in the 2020 legislation is in keeping with the intention of that legislation and does not change policy or practice. The Scottish Greens will support this bill at stage 1.
Thank you. We move to the open debate. I call first Joe Fitzpatrick to be followed by Douglas Ross. Up to 4 minutes, Mr Fitzpatrick.
Thank you, Presiding Officer. I'm grateful for the opportunity to speak in support of the general principles of this bill. As we've heard, this legislation has been introduced to correct an error in law for owners of unoccupied properties' liability to pay non-domestic rates. Presiding Officer, it is perhaps worthwhile setting out what this bill does not do before getting into the purpose and requirements for this legislation. So there will be no change to rate bills as a result of this legislation. The bill will not introduce any additional new costs to businesses or individuals compared to the Scottish Parliament's original intended purpose. I want to offer that reassurance to my constituents and to businesses in Dundee and indeed across Scotland. I also want to give assurance to small businesses that this bill does not impact on the small business bonus. Presiding Officer, as of June this year, small business bonus scheme relief was awarded to over 116,000 properties, accounting for a value of £247 million. 100% small business bonus relief was awarded to over 100,000 properties with a value of £217 million. None of that is impacted by this bill. Presiding Officer, I'll move on to why this bill is needed. This legislation has, as we've heard, been introduced to correct an error in law for owners of unoccupied properties' liability to pay non-domestic rates. The Non-Domestic Rates Scotland Act 2020 devolved powers to councils to provide discounts to owners of unoccupied properties from the 1st of April 2023. And as a former local government minister, I remain an advocate for empowering our local authorities in Scotland and welcome the devolution of powers such as this to our councils. I am surprised by the actions, the position taken by the Conservative Party in this place, because I think if they were to speak to their leaders across local authorities, they would not be wanting to lose this devolved power that they have. However, happy to take intervention for Mr Fraser.
Is Mr Fitzpatrick seriously telling us we should be passing a law that might be illegal and struck down by the courts?
Fitzpatrick.
No, clearly a legislative error was made and has now been identified in amendments made to that Act, and that is exactly what this legislation is here to rectify that error, and that's why we should support it and do the responsible thing. There is politics to be made in this, I understand it, but the Conservatives should step up to the plate and do the responsible thing, the same way as the Labour Party have done. I get the Labour Party will use this to make things difficult for the government in a wider sense. But as Mark Griffin said, it's really important that this legislation passes so that our local authorities do not lose that significant sum of money. So we know a mistake was made, a mistake has been identified. If passed, this bill will apply the necessary changes retrospectively for all levies charged since April 2023, thereby making sure that the intention of this Parliament will be brought into line in the statute book as with what the Parliament had intended. Presiding Officer, without retrospective effect, there would be an unexpected windfall for some ratepayers, but significantly there would be around £350 million in public revenue lost. At a time of extreme pressure on public finances, political decisions by both the Labour and Tory governments in Westminster, I welcome our SNP Scottish Government's approach to ensuring that every penny of public revenue is recovered and allocated appropriately. Presiding Officer, this bill will enable charging of non-domestic rates on owners of unoccupied non-domestic properties, subject to any reliefs that local authorities may choose to put in place, backdated until the 1st of April 2023. The Non-Domestic Rates Scotland Act 2020 was intended to provide greater fiscal powers to our local councils. This bill will ensure that intention of Parliament and the original legislation are realised to their fullest. Thank you.
Thank you, Mr Fitzpatrick. And I call Douglas Ross up to 4 minutes. Mr Ross.
Thank you, Presiding Officer. This is an absolute mess. It's a mess of this government's own making, and each day brings more questions. I repeat what I said yesterday. The Minister for Parliamentary Business said some of us on the opposition benches were looking for conspiracies. Well, we're being aided by a government who is not being upfront and honest about this. But I also want to get something that I think is at the heart of certainly the nationalist support and what I understand is Labour's reason for supporting this bill. And I tried to intervene on the Minister. That was the only intervention he didn't take. I don't take it personally, and I will give way to him to answer this question. Because if the argument that we must support this bill to protect £350 million of public money is true, the Minister will be able to stand up and say that if his bill passes tomorrow at stage 3, that £350 million is guaranteed, that there will be no opportunity, no flaws in the legislation that would allow a legal challenge. Because, as Murdo Fraser and others have said, this is going to end up in the courts. So can the Minister, to this Parliament seeking support for his bill at stage 1 and ultimately tomorrow at stage 3, give a cast-iron guarantee that the money in his financial memorandum will go to local services and will not in any way be effectively challenged in the courts?
Minister.
To Douglas Ross for not taking. He must have sat down too early, but I took everybody that had their buttons pressed. Of course, we go through this process. We take the legal advice on how we need to proceed on this basis, and that robust legal advice underpins what we are taking forward in this legislation, because it's essential that we do take this legislation forward in order to address that issue.
Douglas Ross, I'll give you the time back.
That wasn't my question, so let me ask it again. If the bill passes, the bill the Minister is taking forward, which his government members are supporting and the Labour Party are supporting, to protect £350 million of public money, can he guarantee to members who are going to support his bill that £350 million will be protected, or does he accept there is a risk with legal challenges and that £350 million could be challenged in the courts?
Minister.
What is it? If we don't take this forward, that £350 million absolutely will be lost. But what I also know is that the legal underpinning that we have to take this forward is robust, and that is the basis we're taking this forward on.
Douglas Ross.
I'm sorry, it's not a difficult question. And if the Minister and Joe Fitzpatrick, I'll give way to John Mason in a minute. Joe Fitzpatrick was saying opposition politicians shouldn't make politics with this. If we can't get that guarantee, there is no reason to support this bill, because that money could be lost. It absolutely could be lost, even if you support this bill. Even if you support it, and your argument is support it to protect that money could still be lost because of the way this government legislated and the way this problem has unravelled. Can I get the time back, Presiding Officer? John Mason.
John Mason.
I thank you for giving way. Would you accept that every piece of legislation in this place can be challenged in the courts? We cannot guarantee that any piece of legislation will not be challenged.
Douglas Ross.
I think what we can guarantee, based on Murdo Fraser's letter to the Presiding Officer, this one will be challenged. Not because what we are saying as opposition politicians, what the government are saying themselves in their own accompanying documents to this bill. It won't take a professional lawyer much time to make an argument, because the argument will be to hold up the government's own documents accompanying this bill, because they admit the deficiencies in this bill that they're trying to pass today. Will I get any more time, Presiding Officer?
I can give you the time back.
Michelle Thompson.
Michelle Thompson, briefly.
The member making my intervention. I don't think we should get confused between risk and probability. I think what the Minister is saying is that if they'd done nothing, we have complete certainty that that money would be lost. Obviously, with any legal advice, of course, things can be challenged. So I think we need to separate these 2 points out. But what I would say, with all due respect to Mr Ross, is given that, what exact remedies is he bringing forward, given that we've got this situation? We've got a duty to act responsibly in this Parliament. So I'm interested in hearing about what remedies the Tories have.
Well, here's a remedy. Let's take a little bit longer on this legislation. The fact that the problem occurred in the first place was because during COVID we had an expedited process to put through legislation, and this mistake occurred. A mistake that could cost £350 million. So why not take a bit more time to get more of the legal advice, to inform members more of what is behind the government's problem in the first place and how they're trying to sort it? Don't use another expedited process that potentially could still end up in the courts and cost us £350 million. There are areas I want to focus on, so given that you allowed me some more time, I just want to do that. Because Jeremy Balfour made a very good point in his intervention to the Minister, and I've gone through the letter I received from Graham Day today. So let's just go through that timetable. On the 23rd of June, this government were made aware of this problem. It then went to officials who concluded on the 13th of August that there was likely a problem with the legislation. What on earth were they doing for the rest of June, the whole of July and half of August? If this is such a big issue that needs emergency legislation, surely Scottish Government officials should have been putting it up in lights straight away. We then found out that when they decided there was a problem on the 13th of August, they took more than a week to tell ministers, because it was the 21st of August they informed ministers. Again, where was the urgency? If we're being told this is such a crucial piece of legislation that has to pass in hours and days, why did officials at the Scottish Government think they had more than a week to tell their own ministers about it? But then Jeremy Balfour's point was, when ministers knew about it, when did they start to introduce this legislation? Well, ministers agreed on the 22nd of September to progress emergency primary legislation to remedy this matter. And the minister responding to Jeremy Balfour said, well, we need 3 weeks. There's more than 3 weeks since the 22nd of September. Now, there is recess. There have been 10 weeks. 10 weeks since this government not just found out about this, decided they needed to do something urgently. Please, Minister, do not tell me, do not tell this chamber that you were treating this as an emergency if you sit on it for 10 weeks before you even take it to this chamber. I know I have used all my time, Presiding Officer, and I'm grateful for your indulgence. If I'm allowed, I will.
Very briefly, after which you will need to be winding up, Mr Ross.
I mean, half of what the member says is about we're rushing things through, and half of it is about we're taking too long to fully investigate what the issue was and what the solution to it was.
Douglas Ross.
Listen to what members are saying in this debate. If this was the emergency that the government say it was, their officials should have been taking less than 2 months to bring it to their attention. They shouldn't have been sitting on it for weeks, 10 weeks before they bring it to this chamber. And we shouldn't be rushing this through. That's the whole point. That's what I said to Michelle Thompson. We should be taking our time because we know how bad this government is at legislating. Let's not make more mistakes. Let's do this properly. And I support the Conservatives in opposing this bill.
Thank you, Mr Ross. We move to wind-up speeches. I call first Lorna Slater.
I have no more remarks. Thank you, Presiding Officer.
I then call Martin Whitfield, up to 4 minutes. Mr Whitfield. I'm
very grateful, Deputy Presiding Officer. It is right that this bill is urgent, and it is right that this bill is essential, because listening to the debates and the interventions, there is a reality that at least £350 million will have to be paid if we do not pass this legislation. There is a risk in passing this legislation that, rightly, as with every piece of legislation passed by this Parliament, it can be taken to court for a question on it. And that raises the questions that Murdo Fraser wrote to the Presiding Officer about and that we've heard today, that there is a potential challenge under human rights, and has pointed to earlier cases where the government have not been successful, where those challenges have taken place. And there are a significant number of members in this chamber that are aware of constituents that have suffered as a result of that. But that is a question for the court to settle itself. And indeed, the court may if it so wishes and is inclined, can take into account everything that has been said within this chamber to lead to an indication of what the thinking was, both for ministers and for those of us who sit outside of the government benches on what our views are. And the court will take a decision on that. I'm happy to.
Murdo Fraser.
I'm grateful to Mr Whitfield for giving way, and I'm following his argument with interest. But would he not agree with me that rather than us spend time passing this legislation in the expectation that it will then go to a court to resolve, we should actually get this right here, because that's our job as legislators?
Martin Whitfield.
But the reality is that within this chamber and within the legislative procedures we have, we cannot prevent, we cannot stop. We can take steps to minimise it, and indeed, given the very short, very technical nature of this bill, and absolutely, I think, the risk lies in that retrospective element. The very tightly drafted bill is seeking to do everything it can to bring into actual legislative fruition what people have understood to be the law for a considerable period of time. I do hope that the government are in a position with regard to ongoing actions by local authorities to recover, that they can give the same assurance in respect of underwriting any potential risks there, which will be a figure much smaller than the 350 million, but is a realistic figure where it would be raised. And to the fact, if we delay to look again at this situation to come up with a solution, in all probability we will still come up with a very short bill that looks not dissimilar to the one that we have, but we are opening the period of time where there are more and greater potential risks to our local authorities as the recovery agents. And so we need to balance, on one side, the legal risk and the real financial risk of not passing this bill, hopefully tomorrow night. Not to do so would be a true dereliction of duty to every taxpayer out there, because at the end of the day, a government undertaking is actually in reality still taxpayers' money. So I am conscious of time. We will support the bill tonight. We will be looking for explanations at stage 2 from the government and assurances as we go forward. But it is the right thing to do, and maybe it is a salient lesson for this Parliament about how we go scrutinising legislation. I'm grateful, Deputy Presiding Officer.
Thank you. And I call Murdo Fraser up to 5 minutes. Mr Fraser.
Well, thank you, Presiding Officer. Douglas Ross is right. This is a shambles, an absolute shambles. We've dealt with emergency legislation in this Parliament before. Emergency legislation is brought forward on a very, very tight timescale where there is a political consensus to try and fix a problem that needs to be fixed urgently. We do not have a consensus now because we've unravelled, just in the last few hours, there are key legal problems facing this bill. And my colleague Douglas Ross has pointed out the information being provided by the Scottish Government has been inaccurate in terms of the timing. They had since June, potentially, to resolve this. They're trying to force it through Parliament in 24 hours. Yes, of course I'm going to.
Do we have consensus across the chamber that we don't want to automatically reimburse £350 million?
Murdo Fraser.
Well, I absolutely do not want to see a hole in the public finances, but there's no point passing a bill that's not going to achieve that because it's defeated by the courts, as I believe there's a very real risk it will be. Now, this is all down to SNP incompetence. It's all down to incompetent drafting. We shouldn't be having to spend parliamentary time sorting out the SNP's mistakes because someone didn't do their job properly at the time. And look at the substance of the issue. The rationale, if I remember correctly, behind removing empty property relief, which was simply another tax raid, of course, on businesses, but the rationale at the time was the belief that this would incentivise landlords to let empty properties more easily. And I'm interested to know, and maybe the Minister in winding up can address this question, has this been achieved? Do we know, are there fewer empty properties now than there were in 2020 when this was legislated for? We certainly know that the high streets are full of empty retail and office premises. The labour market changes, increased working flexibility means there's less demand for office space, whereas retail's under pressure. And we've even, as Craig Hoy mentioned earlier, seen landlords actively demolishing perfectly sound properties because they can't find tenants in the short term and they cannot afford to pay their rates. So as a policy, it's not delivered on its ambition. But if the Minister wants to correct me with some numbers in winding up, I will listen to him. But I want to come back to this whole legal question, because it seems to me the law in this area is quite clear. You cannot pass retrospective legislation to take away people's rights, except in extreme circumstances. And this bill seeks to retrospectively extinguish a right that exists in Scots law, that people, as the law currently stands, would have the right to claim under the principle of unjust enrichment. Now, the European Court of Human Rights is very clear about this. I've read the policy memorandum from the Scottish Government. The policy memorandum makes the case that the public interest in relation to the financial consequences to the state outweigh those rights of property under Article 1, Protocol 1. Let me just state what the European Court of Human Rights has said. It's clear that financial considerations for the state or the wish to avoid the consequences of a government mistake do not of themselves constitute a sufficient justification for extinguishing private law rights. And in fact, the court has treated retrospective legislation designed to rescue the state from its own error with particular suspicion. And what's very clear, and I quoted in my letter to the presiding officer the case in 2006 of Maurice versus France, where the court says this in paragraph 87. The court has already found that the taking of property without payment of an amount reasonably related to its value will normally constitute a disproportionate interference, and a total lack of compensation can be considered justifiable under Article 1 of Protocol No. 1 only in exceptional circumstances. And that is the case made in the policy memorandum. And that, I'll give way in a second to Mr Balfour, and that statement in that judgment reflects on a series of other judgments from the European Court. The 1994 case of the Holy Monasteries against the State of Greece, a 1994 case of the former King of Greece and others against Greece, and the 2001 case of Jan and others versus Germany. So it's a settled law. I'll give way to Mr Balfour.
Jeremy Balfour.
Can I thank Mr Fraser for giving way? Can I just seek clarity from Mr Fraser? Does he believe that there is no way legally for this money to be got back? Or does he believe that if there was further time of scrutiny, there could be a legal way around this?
Murdo Fraser.
We simply don't know the answer to that, Mr Balfour. What I can say is the case currently being made by the Scottish Government in its policy memorandum is, in my view, having looked at the case law, hard to sustain because they are referring to exceptional circumstances. Now, the exceptional circumstances in this case are legislative incompetence on the part of the Scottish Government. I find it very hard to believe that a court in Scotland would uphold that as a justification for breaching this very strong presumption against retrospective legislation taking away the rights of property under Article 1, Property 1. If I have time...
Very, very briefly, Martin Whitfield.
I'll give way.
Well, circumstances, not that everyone understood what the law ought to have been from that date.
I fear, Mr Whitfield, under the law that is an entirely irrelevant matter, because the court will look at what is actually legislated for, and it is the letter of the law that will be important here. So, to conclude, presiding officer, if I can, why are we in this mess? Who's taking responsibility? Why did nobody in the Scottish Government, in the civil service, in the ministerial team, in the legal department spot this mistake? It's hugely embarrassing for the Scottish Government. We've yet to hear an apology for the errors that have been made. I'm genuinely sorry that the Labour Party are supporting this bill. I know Mr Griffin referred to his concern about costs. If this ends up going to court, Mr Griffin, the costs are just going to mount up and up and up to the taxpayer, and almost certainly, I believe, if we pass this, this will go to court because of the very large sums involved that people will feel they have a justifiable legal claim to make. So it's not the job of the Scottish Conservatives, as the principal opposition here at Holyrood, to help this failing SNP government clamber out of the hole they have dug for themselves. If other parties want to come to their rescue, so be it, but we will not.
I'm going to now call on Ivan McKee to wind up. Minister, around 6 minutes, please.
Thank you, Presiding Officer. So, first of all, I'd like to thank members that have taken part in this debate. And I really welcome the recognition of the seriousness of this issue and the need to move at pace to address this challenge from the Labour Party, from the Green Party, I believe from the Liberal Democrats. I can't see any in the chamber, who are also in support of us taking forward this measure. I think that recognises a mature approach. It understands the situation we find ourselves in, and that we need to work together as a Parliament. Indeed, those outside would expect us to do that, to be able to address this particular issue. And I think that contrasts with the approach of the Conservative bench, who are frankly just taking this as an opportunity to grandstand, which coming up with no answers and just looking for. I'll make some progress and I'll come back to Paul Sweeney in a minute if that's okay. I think it's worth first of all just reflecting back on the original bill. The original bill, as I understand it, wasn't expedited. It took place over a number of months, and it was stage 3 went through in early February of 2020 before COVID had taken effect. And the policy intent, of course, was agreed. And I'm not sure Conservative interventions have been a bit contradictory and incoherent this afternoon, but I think that they don't have a position that the policy intent is something that they disagree with regards to devolving this power to local authorities. That, of course, was passed unanimously at stage 2 at committee. And with regards to the specific measure that Murdo Fraser had asked about, we've actually got some data from Perth and Kinross Council, which is that 89 exempt properties they had at the 31st of March 2023. They've indicated that the removal of the exemption has generally had the desired effect. 41 of those properties are now occupied, 29 are still empty. 7 have had their rateable value reduced to nil by the assessor, and 12 have been deleted or merged with other properties by the assessor. So, by and large, from that evidence, that suggests that the intent has been fulfilled. But, of course, the intent was primarily to give that power to local authorities, and again, something that we never tire of hearing from the Conservatives about the need for us to devolve powers to local authorities. So I don't really understand their issue with that. It's also worth pointing out that in terms of the process we're going through at the moment, this was agreed at Bureau on a cross-party basis. Representatives from all the parties were at that meeting, including the Conservatives business manager, who signed up to this process and was supportive of us having this stage 1 debate on the Wednesday, the day of the UK budget, rather than having it tomorrow morning. So again, cross-party support on the policy intent, on passing that amendment when it was originally passed, and indeed on the process that we are currently going through. So I'll take Paul Sweeney, because I think he was first.
Paul Sweeney.
I thank the Minister for giving way. In the spirit of cross-party working, I think there is cross-party consensus that has generally been successful in Glasgow, but there have been a couple of instances where the policy has had unintended consequences, most notably Govan Hill Baths and also Flemington House in Springburn, where dozens of small businesses were evicted because the owner had to pursue a temporary relief of 12 months. So there are cases where it could be improved. Would it be possible to have a light touch amendment in this bill to signal where best practice should be adopted by local authorities, not militating against their devolved rights, but just signalling where there could be improvements to be made at a national level to preserve listed buildings?
Minister.
I do recognise the members' concern on that issue, and I also recognise the significant work that he does with regard to historic and listed buildings generally. I've received correspondence from the member on this issue. I think what I would say two things: that this bill in particular is about having a very focused approach, so that we're able to take through the measures that need to be taken to protect that revenue and provide clarity in the rate system. And I think it would be a mistake to complicate that further, but I do absolutely recognise the issue that he has raised and the local applicability of that, and I'm very happy to work with him on how we can seek to address that issue through other members. Indeed, I shall.
Murdo Fraser.
I'm very grateful to Mr McKee for giving way, is able to advise us whether Scottish Government lawyers have been able to find any precedents in case law that support the contention that legislative failure amounts to an exceptional circumstance as would be upheld to defeat the presumption under Article 1, Protocol 1 of the European Convention.
Minister.
Thank you. Yeah, what I'd like to comment on is the issue of retrospective legislation. I think it's at the core of what Murdo Fraser is talking about. And legislative legislation isn't inherently unfair or incompatible with human rights. It's been passed by this Parliament before. The Erskine-Bridge Toll Act 2001, the Criminal Procedure Amendment Scotland Act 2002, the Crofton Amendment Scotland Act 2013, the Lands and Buildings Transaction Tax Relief from Additional Amount Scotland Act 2018. Several occasions retrospective legislation has been taken forward successfully. The Scottish Government acknowledges that great care must be taken when changing the law with retrospective effect, but there's a general public interest in the law not being changed retrospectively. However, sometimes it can be justified and proportionate to do so, and this is one such case. Crucially, the bill is not raising new revenue, but seeking to protect revenue already collected. The affected ratepayers have already paid the rates demanded, so retrospectively validating those rates will not pose a severe or undue burden on those ratepayers, and at most it will deprive them of an unexpected windfall that they had not expected or indeed budgeted for. And against that, of course, must be weighed the community interest, and failing to ensure that legislation is retrospective would mean a potential loss, as has been highlighted, of up to £350 million in public revenue. This could result in either very significant cuts to public services or compensatory tax rises being required in subsequent years. In that context, the Government considers the bill to strike a fair balance between the community interest and the rights of individuals, and the Government considers the bill to be compatible indeed with convention rights and within the legislative competence of the Parliament. I'll give way to, I don't know who was first, can decide between you.
Craig Hoy.
Minister for giving way. Will he answer the question that was put to him by Mr Griffin? We know that the Government is on the hook for the £350 million, but is he giving a guarantee to Council that all other associated costs that might arise from this, interest, legal costs or the recovery of fees associated with debt recovery, will be underwritten by the Scottish Government?
Minister.
The Government will have conversations with COSLA on this matter now that it's been raised, and we expect that individual councils, of course, will be taking their own legal advice on how they proceed. But I've laid out earlier in terms of how the effect of this retrospective legislation would be taken forward. So, in conclusion, Presiding Officer, I think I've probably taken enough. I urge members to recognise the importance of the matter this bill seeks to address. It is vital in order to maintain the credibility of the tax system, protect public finances and enable the non-domestic rate system to continue operating as it had been understood by local authority and ratepayers indeed since the 1st of April 2023. The bill, if passed, will not introduce any new additional costs to businesses or individuals compared to the Scottish Parliament's original intended policy. The Parliament voted in 2020 to devolve empty property relief to local authorities to provide greater local fiscal empowerment for councils by letting them, rather than the Scottish Government, decide whether to offer any rates discounts to the owners of unoccupied properties. And this bill will now give full effect to Parliament's original intention by clarifying the legislative position as quickly as possible, and I would urge members to support it. Thank you, Presiding Officer.
Thank you. I call Douglas Ross for a point of order.
Thank you, Presiding Officer. Before you assume the chair this evening, I raised in an earlier point of order the letter we've had from Graham Day correcting the official record from yesterday, where he had informed Parliament that the Government first became aware of the error in their law in August, and it now turns out that was actually June. My question to the Deputy Presiding Officer was the information that was provided to other party representatives. We were certainly told the August date, and I questioned when you were informed. In the discussions that you had with the Government about this emergency legislation, did they state to you as Presiding Officer, the person we've elected to be representative of all MSPs, not just government ministers and MSPs, did they use the date of August, or were you informed of the June date?
I was made aware of the introduction. I received notification of this bill being within the Parliament at the beginning of November. I am not aware of the dates to which Mr Ross refers. The bill came into the building at that point for the usual pre-introduction checks. Mr Ross, Douglas Ross.
Thank you. And I wasn't clear. That's a 3-week period that the government would have to inform you of a bill, which takes us to today. My question was, when the government were informing you of this, did they alert you, as they did, in my understanding, opposition parties, that the error was first notified to them in August, or did they tell you the true date, which was June?
I do not believe such dates were discussed with me by the government. That's not a point of order, Mr Ross, but we will continue with our business. We've concluded the debate on non-domestic rates liability for unoccupied properties, Scotland Bill at stage 1, and it's now time to move on to the next item of business, which is consideration of motion 19928 in the name of Shona Robertson on a financial resolution for the non-domestic rates liability for unoccupied properties, Scotland Bill, and I call on Ivan McKee to move the motion.
Moved, Presiding Officer.
Thank you, Minister. The question on this motion will be put at decision time. The next item of business is consideration of business motion 19921 in the name of Graham Day on behalf of the Parliamentary Bureau setting out a business programme, and I call on the Minister to move the motion.
Move, Presiding Officer.
Thank you, and I call on Megan Gallagher.
Presiding Officer. Yesterday's responses to my urgent question on grooming gangs were nothing short of a farce. Once again, the Justice Secretary passed responsibility onto a junior minister to answer questions on her behalf, while she sat in this chamber avoiding any scrutiny. At a time when Scotland desperately needs leadership on grooming gangs, this government only offers evasion and silence. Victims are being failed while ministers sit on their hands. I raise the unprecedented intervention by the NSPCC, who have made it clear that Scotland has no real understanding of the true scale or nature of grooming gangs operating in our country. That's an alarming admission from the leading child protection charity. The Justice Secretary claimed that the National Child Sexual Abuse and Exploitation subgroup addresses grooming gangs. Yet, in its 27-page report, it does not mention grooming gangs once. So I'll try and ask again, who is actually investigating grooming gangs in Scotland? Because it's certainly not this government. The Cabinet Secretary told me it's for me and others to present a case for an inquiry. Well, the evidence is already overwhelming. The NSPCC has said that the scale of grooming gang activity is unknown. More victims are coming forward every single day with harrowing, life-changing testimonies. Families are being torn apart by some of the most appalling crimes imaginable. What more evidence does this Cabinet Secretary need? Victims don't need a government that is merely open to an inquiry. They need a government that's willing to initiate one, willing to listen to victims, willing to act and willing to confront the failures that have allowed for these crimes to continue unchecked. Leadership is not about sitting on the fence. Leadership is about stepping up and doing what's right. A grooming gangs inquiry is not optional, it's essential. It is the only way to uncover the scale of the problem, to protect children and to ensure that the victims' voices are finally heard and finally believed. Presiding Officer, I take no pleasure whatsoever in raising these issues, but until this government stops ducking responsibility, I will continue to speak up for the victims who have been ignored for far too long, even if that means that I need to return to this chamber every single sitting parliamentary day. And I give way to Pauline McNeill.
Pauline McNeill.
Thank you to the member for giving way. Yes, I had concerns too that the Cabinet Secretary was not here to answer what is now become a really important national question. And perhaps we might slightly disagree on the approach, but where we do agree is that the government's complacency over this is giving real cause for concern to us in this chamber, to victims and agencies. I called for a case-by-case review at the very least. I got no answer to that. Does she share my frustration that we're even trying to get answers that we're not getting in this chamber?
And that's exactly why I'm here this evening, Pauline McNeill, because there is a frustration. We can't get the answers. We can't seem to find any mechanism that's afforded to MSPs in this place to allow for the questions that we have asked. And I know that Pauline McNeill has asked serious questions in relation to misleading of Parliament and certainly comments that have been put on the record by the Cabinet Secretary. And that's why I do believe that there has to be a statement or another form of mechanism to allow MSPs in this place to ask questions and actually finally receive the answers from this government. Or better yet, let's have the inquiry now. Because victims deserve justice, they deserve to be heard, they deserve an inquiry. That's why we need an inquiry now. Thank you.
Thank you. And I call on the Minister to respond on behalf of the Parliamentary Bureau.
Presiding Officer, let me respond to this from the perspective that I believe it would have been intended, which was to call for a statement. I think that was covered latterly in Megan Gallagher's contribution. This has been there's been ongoing engagement with Parliament across this topic and related child sexual abuse and exploitation issues. An urgent question was answered on the understanding of the scale and the nature of child sexual abuse and exploitation in Scotland yesterday, that included responses to the National Child Abuse and Exploitation Strategic Group and its programme of work across workforce data and the consideration of mandatory reporting. An urgent question from Liam Kerr was also answered on Alexis J being misrepresented on the 19th of November. I want to make some progress, because I think I will answer the point for the member. On the 19th of November, this clarified the position in Professor J's valued membership on the group, alongside other expert partners, in our continued collective efforts to tackle this horrendous form of child abuse. And an oral PQ was answered on Wednesday, the 12th of November, covering the steps being taken to prevent group-based child sexual abuse and exploitation in Scotland, covering the prevention-focused approach of the strategic group to collectively improve how harms identified, reported and responded to by statutory agencies and other partners. Now, that group met on the 25th of November. The minutes have been finalised and actions ratified based on the advice that will flow from the strategic group to ministers to be considered. We will be able to establish the most effective next steps. And of course, the most effective way to inform Parliament about the work of the strategic group and the response to ongoing calls for an inquiry into grooming gangs in Scotland will be through a comprehensive statement to Parliament that will be undertaken as soon as possible and before recess. And for the benefit of the Chamber, that's an undertaking I gave 2 weeks ago through the usual Bureau process, in which, of course, the Conservatives participate. So I'm a little surprised to have the Tories calling for something they've been told is coming. Presiding Officer.
Thank you. Minister, can I confirm that you were about to take the intervention from Ms McNeill?
Sorry, I wasn't aware of the intervention.
Okay.
I'm happy to take that.
Ms McNeill.
Thank you very much. I just wanted to draw the Minister's attention to the question I asked twice. It is a serious question. So there's been an apology made because Professor J was quoted in a debate where we made a decision on whether or not we would have an inquiry or not. Now, I've since asked the question, have the government since spoken to the expert in child abuse, Professor J? And I can't seem to get an answer. And it may be that in this 25th of November working group, that's where it all happened. But can the Minister give me some clarity now? Is Professor J now satisfied that you've taken her expert advice?
I will write to Pauline McNeill, having looked into that matter for her.
Thank you. And I will just clarify for the Chamber, this item of business is about members who wish to change forthcoming items of business, and that should be the focus. So the question is that motion 19921 be agreed. Are we all agreed? The Parliament is not agreed. Therefore, we will move to vote, and there will be a short suspension to allow members to access digital voting.